Harold, I was just on all the circumstances point.
Yes.
And the fact that the amendments to the rule following Sir Rupert Jackson's report has not changed the position that when determining whether costs are proportionate, the court is still required to take into account all of the circumstances of the case under Rule 44.4. This is perhaps illustrated.
And not limited by 33.
Yes.
By 44.25.
Yes.
That's a point.
I mean, in our skeleton at paragraph 63, we set out the changes that were made to Rule 44.3 in bold. Obviously, we haven't set out 44.35 because 44.35 was new. But the text of 44.3.2 was amended. It's page A24 of the bundle, paragraph 63 of our skeleton.
Because I think those skeletons were loose in there for some reason.
Should be A20.
What paragraph must go?
It's paragraph 63 of our skeleton. We've just put in bold the added words that came about as a result of the amendments to the rules following Sir Rupert Jackson's recommendations.
But does that help us particularly?
Or simply, the simple point is that there's been no change to 44.3.2 beyond.
I see what you're saying.
Yeah, so that
This was designed to deal with Lowndes,
yes,
because Lowndes said if it was necessary, then it would, as it were,
Correct.
be deemed to be proportionate.
correct.
Now, it can be disproportionate and so can be disallowed or reduced, even if they were reasonably or necessarily
Correct.
incurred.
Correct.
So subject to any other argument, that was the purpose of it.
Absolutely. That was
Yeah.
the purpose of it. And whilst on that point, so those looking at Rule 44.3.2a, we say that the purpose of the rule change is to augment the court's powers, to give the court a greater flexibility to disallow costs on the grounds of proportionality than was hitherto the position under Lowndes. And as we describe at paragraph 66 of our skeleton, it was recognised that Lowndes heralded a form of legal fiction, in a sense, because it treated as necessary costs as being proportionate to the matters in issue. And that gave rise to what's being referred to as the nodding respect to proportionality that arose as a consequence of that Lowndes test. And Sir Rupert Jackson's amendments, the amendments made by the Rules Committee, give the court the power to do a little more, to say they're not actually assumed or presumed to be proportionate, they may in fact be disallowed or reduced. Now, whilst in the authorities bundle, just behind tab 5 it's a small point, but it may chime home. There's when the rules direct that it's only the circumstances of the case to be taken into account, the rules say so. And we have a good example of that at Rule 3.9, tab 5, where the Rule 3.91 says the court will consider all the circumstances of the case, tab 5 of the authorities bundle.
As opposed to all the circumstances.
As opposed to all the circumstances. It's a small point, but it just helps I think, make the point. Now, in terms of drilling down to what these concepts, as my Lord the Master Rolls identified, we've got proportionality, we've got necessity being referred to, necessarily incurred, and we've got reasonableness. Now, we say a very helpful starting point and remains applicable principles, I would submit, continue to pertain as a result of it. The case of Rogers is a must reading in terms of understanding these rules because as I say, it was only 2A that was changed by 2A and the introduction of 2.5 that was the change brought about by the Jackson reforms. Costs still had to be proportionate and still had to be reasonable under the old pre-Jackson reforms. And this court in the Court of Appeal, its seminal case of Rogers, grappled then with what the proper approach was to reasonableness and proportionality in respect of ATE premiums, and it's behind tab 7. And a similar process was undertaken, as my Lord Justice Irwin knows. We appeared before him. We looked at Rogers, where Rogers, the Court of Appeal ordered effectively a fact-finding hearing. Various AT insurers attended, cross-examined. There was hearing before Master Hurst, who produced a judgment, which was then placed before the Court of Appeal, and the Court of Appeal then gave its guidance. And the discussion is paragraph 96. Really, it's where it all starts. Might I just add in close there, my Lord? There's been a request by the law reporters, or the press included, I think, for a copy of the assessor's report. Now, we've not provided that to anybody at the moment because the assessor's report was certainly provided to us on terms that Mr Justice Kerr pronounced at the beginning, which is that it was confidential to the parties and to the court, and it's a matter of the Court of Appeal, ultimately, of course, what it does with this assessor's report. But for the purpose of clarifying the position, it's a matter for your lordships, but I would have thought that should remain the subject of remaining private, subject. Well, maybe it shouldn't, but I just raise it with you because we have had a request for the assessor's report to be, because we haven't handed it over on the basis that we assumed it not to be a public document until it's referred to by your lordships in your judgment. But technically it's being referred to in open court today, and I'm a bit concerned that in those circumstances
The hearing was in public.
It was. It's just we're subject to the we were subject to the.
What was the reason for that?
Well, I assume it was because there wasn't a reason given, but I assume it was because the assessors felt they were reporting to the Court of Appeal.
Yes, quite.
As opposed to the public at large.
So they thought it was the Court of Appeal's confidentiality, as it were, rather than
yes.
theirs.
Well, it may be one other thing, which is I recall at the hearing before, when this was ordered, the possibility was opened of the Court of Appeal disagreeing with some of the contents of the assessor's report.
Yes.
Because of course technically it's a report to the court.
It is.
Else. So it may be that was what was in Mr Justice Carl's mind.
Also, I think, is it right, Mr Maloney, I think there are some criticisms on your side of the assessor's report, isn't there, aren't there?
Well, no, I think the position for my clients, my lord, is we view the assessor's report as what it was, which was a fact-finding exercise. Even insofar, and I don't think they really do this, but even insofar at any point it is said they express a view on the ultimate issues in the appeal, and of course we may differ from them, but I don't think they go that far.
That attached to one of your closing arguments on the Demouilpied case, there's a whole, you've got a whole number of documents, 8 pages where you're commenting on it.
We have a lord, and that's where we seek to highlight, because of the unusual nature of the exercise that's being carried out, aspects of the facts that have been found by the assessor, which we consider it is appropriate for this court to address as part of its judgment.
Well, I suppose let's start with asking the parties whether you have any objection to them. No, so you have no objection. Do you have any objection?
No, we don't.
So I think we will have to discuss amongst ourselves.
Yes.
Probably whether there's any issue about that.
I don't have any objection but we can discuss at the end.
I think we should. So I mean, if this is right, we'll discuss it at the end of the day, and then make a decision on that issue. So if we say it can be released, it can be released overnight. That's right.
I had envisaged that would be subject to any points of detail, that would just be an appendix to the judgment in our case.
Yes.
I wasn't going to say that in the judgment, but have it as an appendix.
I mean, do you want to discuss it in more detail? Do you have just that section?
I'm happy to say.
No one's happy with it released. Well, the consensus seems to be that it can be released. So you don't have to wait. So that can be released now.
Thank you very much.
Right, B8, yes, no.
So paragraph
Discussion.
96, discussion. First occasion on which the reasonableness of the agreement has been considered authoritatively. And you'll see, I'm not going to read it, all paragraph 96 sets out the issues. It's a very similar question to the question your lordship is being asked to consider.
Which particular passages?
So the paragraph 104 refers to the two-stage approach in Lowndes, and at paragraph G to H, this was a passage referring to the case of Sims and the Law Society, where Lord Justice Carnwath has stated that the reasonableness of the costs in practice may overlap with issues of proportionality. With respect, we think this observation needs to be treated with some care. Reasonableness and proportionality are conceptually distinct. Point that your lordship made,
Yes.
partly why I pointed that out to you. And then over the page, at the top of the page, paragraph A, if the court concludes that it was necessary to incur the stage premium, then, as this court's judgment in Lowndes' case shows, it should be adjudged a proportionate expense. So that's the old rule, that's the old Lowndes approach applying. I accept that doesn't now follow, as my Lord Justice Coulson observed. But the observations here are still relevant and helpful. Necessity here is, we think, not some absolute litmus test. It may be demonstrated by the application of strategic considerations which travel beyond the dictates of the particular case. Thus it may include, as we are persuaded it does, the unavoidable characteristics of the market in insurance of this kind. It does so because this very market is integral to the means of providing access to justice in civil disputes in what may be called the post-legal aid world. Now we would submit that nothing said in that part of paragraph A is out with the current regime and the current policy.
What that does seem to run counter to what would be my instinctive position, which I've already outlined, which is that necessity in this context is also different from reasonableness and proportionality, and it would relate to something which cuts across all litigation and
Yes.
not a particular category.
Well, the point I was focusing on really is that necessity, as a concept, isn't confined to the dictates of the particular case. It's the all the circumstances argument,
Yeah.
which as I say, the Court of Appeal in Rogers accepted that strategic considerations, as he goes on, as the Court of Appeal go on to look at, that we have to have an AC market, it needs to be there to provide access. It is a consideration when looking at whether something was proportionate. So we would, and bearing in mind, it's just the test that's changed, not the principles. So the principles of necessity, the principles of proportionality, principles of reasonableness are still there. It seems to us difficult for the court to conclude that strategic considerations, which pertained before the 1st of April, are no longer relevant after the 1st of April. That would be odd.
Are those sentences part of the ratio of the case?
Well, yes, because what the Court of Appeal eventually says is that if the premium was necessary, in that particular case, the court in paragraph 108 took into account all the circumstances in determining whether or not the premium was a reasonable and proportionate expense. It took into account all the circumstances, which included the strategic considerations that are referred to in paragraph 105. So
the trouble is, how does that sit with 44.32a? Because there now we're told by Parliament, by way of statutory instrument, that it contemplates that something may be disproportionate even though necessary.
it contemplates it. It does contemplate it. It says it may be.
No, that's a different point. It says you may reduce.
Yes, or
Yeah, I think I'm not sure the wording.
costs which are disproportionate in amount may be disallowed or reduced.
May be disallowed. So the may goes to the discretion. I'm making a different point, which is this case, Rogers and Murphy, if this is part of the ratio you're saying, says that if something is necessarily incurred, I don't think they limit it to ATE, insurance premiums, but if something is necessarily incurred, he says pragmatism, principle and pragmatism together compel the conclusion that it was a proportionate expense. And what I'm saying is that that is now contradicted by Parliament, because Parliament has, as it were, necessarily contemplated that something may be both reasonable and necessary, but disproportionate.
Yes, we're at cross purposes. So I had accepted. So that sentence my Lord has just read out at the end of paragraph 106 is similar to the first sentence, or tied to the first sentence at the top of the page, which I accepted, no longer applies because of Lowndes. What I was seeking to hang on to, so to speak, in terms of this judgment, is the test about what is necessary. There is no litmus test. It may be demonstrated by the application of strategic considerations which travel beyond the dictates of the particular case. That's all I'm saying in this passage.
Maybe needs to begin with the earlier part of paragraph 105. The attack was on the proportionality of the premium.
Yes.
Then we move to look on how that is defined, and because of Lowndes, what the court was saying, it seemed to me, was that because you can equate necessity and proportionality, the two were for them the same.
Yes.
But the point at issue was proportionality, not necessity.
Correct. It was.
And in that context, the court was saying circumstances of the market were relevant.
Were relevant. That's right. And that's the piece that I seek to hang on to, because we're talking about proportionality here. We're not talking about some different concept. When you're looking at what is proportionate, all of the circumstances within the rule, the same rule, 44.4, the same rule, draw in and include the strategic considerations which travel beyond the particular case. That's all the point I'm seeking to make.
Right. So you're not relying.
And the final sentence.
You're not then relying upon the principle stated here that if something is necessarily incurred.
That's right. I'm not.
Must be a
No, we were at cross purposes, my lord. I'm not. I accept that. Must have been. That's ameliorated. It's been
It's simply that when you're doing the proportionality exercise, this is authority for the fact that you take in all the broad.
That's all I'm seeking to say. Probably very, very clumsily, but and in that same paragraph, paragraph A to B, says it may include, as we are persuaded it does, the unavoidable characteristics of the market in insurance of this kind. It does so because the very market is integral to the means of providing access to justice in civil disputes, in what we may call the post-legal world. We do say that part of the paragraph, likewise, is part of all of the circumstances that the court can have regard to. And then in 108, which I was going to take you to, as I mentioned a moment ago, first sentence is that the evidence has changed, as it has here. If more evidence had been available to this very experienced judge, he would no doubt have reminded himself of the fact that the AT premium was large compared with the agreed damages of 3,000. Did not necessarily mean that it was disproportionate. So in the particular case, the premium, he reduced the recoverable premium was reduced to £900. It was originally claimed at 4,860. So it was substantially reduced, and the 4,860 premiums exceeded the £3,000 in damages. To put the facts in context, and what Lord Justice Brooke was saying here was that if evidence had been available to this very experienced judge, he would no doubt have reminded himself that the fact that the AT premium was large compared with the agreed damages did not necessarily mean it was disproportionate. Under CPR 44.51, a court must take into account all the circumstances. These include the financial risks faced by the insurer. We say that still applies. It must do, because all the circumstances are still applicable. And then the court in fact held it was impossible to say that the particular premium, a total premium of 4,860, paragraph 110, was unreasonable given the risks, the cost risk in the case. Now, the Court of Appeal then gave guidance about in the future, paragraph 117, 116 through to 118. That particular case concerned a premium which was staged, so it went up incrementally depending on the stage at which the proceedings had reached, and the Court of Appeal said that there should be an obligation to inform the other side about that. That's paragraph 116. Then 117, if an issue arises about the size of a second or third stage premium, then it's ordinarily sufficient for the claimant solicitor to write a brief note for the purpose of the assessment as to how he came to incept the particular product for his client. District judges and cost judges do not, as Lord Hoffman observed in Kellery and Gray, have the expertise to judge the reasonableness of a premium, except in very broad brush terms, and the viability of the ATE market will be imperilled if they regard themselves, without the assistance of expert evidence, as better qualified than the underwriter to rate the financial risk the insurer faces. Whilst we're in the authority, paragraph 108 deals with a point that's been recently developed. I mean, there is no response notice, but I noticed from my learned friend Skeleton that he's seeking to argue that your lordship should disallow the element of the premium in this case that insures against the risk of not recovering all of the premium back. And he says it's not recoverable under the regulations, but the Court of Appeal in Rogers and Merthyr Tydfil held that it is permissible and reasonable for the premium itself to be insured within policy, and it's recoverable. And we say the wording of section 29 is very similar to the wording of the regulations, that it should still be recoverable here. But I'll deal with that more by way of reply. So that's the key point. The key point that one gets from Rogers is that I entirely accept that the Lowndes test, the judgment needs to be read against the fact that the Lowndes test no longer applies. But we say that, importantly, factors outside the particular factors of the case, the circumstances of the case, including the characteristics of the insurance market and the need for the policy to be recoverable in principle to enable access to justice and provide the support for the policy that underpinned the regulations here, are equally relevant as they were then as they are today.
You say that the passage in the middle of paragraph 117, the starting district judges and cost judges, is applicable today as it was then.
Absolutely, yes.
And that's dealing, in fact, on the face of it, dealing with both block rated and individual.
It is. I mean, certainly in block rated. I mean, I accept that there's been. I think it will be said. I dare say it will be said that there's been a lot of experience since this case. That judge. Well, so far as that is concerned, we still submit that, particularly in relation to block rated premiums, it's just simply not open to a judge without any evidence at all to say this is unreasonable, without proper comparable evidence. I mean, or disproportionate, either way, because there isn't the expertise within the judge's experience to arrive at that. Is it like any other decision making?
Say, in a straightforward one expert case, it was disproportionate to enter into such insurance at all, because the risks of costs were so low that the premium was more than the risk.
No, and so we're turning to McMenemy. That was the argument we faced in McMenemy, that you should wait, effectively, you should wait until you know more about the number of experts you're going to instruct and so on before you take out the policy. And the Court of Appeal said, no, because again, you end up with this case. I think the policy reason behind we will submit the policy reason behind the McMenemy
book is distorted.
That's right. That's right. And you also end up in a case-by-case assessment of whether it was reasonable to take out, which a reading of McMenemy, the Court of Appeal's approach to McMenemy said, look, we don't want assessments of these things in every case, and we
That's
were
what Lord Justice Lewison says. He says, I
Right.
don't favour the
We
case.
can turn to McMenemy now. Actually, it's the next case.
Anyway, as far as I can see, what you get out of this case is basically the proposition that you've made in the exchanges with the bench, which is that when you're looking at necessity, you can take into account wider circumstances than just the facts of the case.
Yes.
That's the first point.
Yes.
And I suppose the point that, again, has just been pointed out to you by my Lord, which is in 117, which is, that, you know, without expert evidence, you can't second guess the market.
Correct.
Those are two.
They're the 2 points.
All right. Then let's look at McMenemy.
So this was a case that was heard, Lord, last in October 2017. It was a what I call a case about prematurity. It was a case about whether or not the solicitors and the client who took out the insurance should have waited, whether there's an obligation to wait before you take out the policy. And you can see from the head note, it was the first case under the Health. It was the first case in which these particular regulations had been considered. It was not the case that the reasonableness or proportionality of taking out an AT premium should be assessed on a case-by-case basis. So there's a policy decision being made by the Court of Appeal here that the reasonableness or proportionality of taking out an AT premium, so the inception of it, shouldn't be assessed on a case-by-case basis. The court concluded, look, these things are necessary. There are going to be swings and roundabouts. Some cases you might not end up having an expert at all, and sometimes you might have lots of experts. But the policy message here was that so far as reasonableness and proportionality is concerned, we start from the proposition that it's reasonable and proportionate to incept it in every case. Right at the outset, when you sign up with your solicitor to the funding agreements. And that's why we don't pursue any longer. That's why ground one is no longer being pursued. It dovetailed this case. Now, so far as the judgments concerned, there were two cases, the Reynolds and McMenemy, but they both raise the same issue.
Which passages did you want to refer to?
So, just to answer my Lord Stephen Irwin's point about on paragraph D, page 2688. It's not actually numbered because it's part of the appeal summary. So paragraph D, page 2688. You can see that the defendant requested an oral hearing in respect to the premium. District Judge Rogers held that it was unreasonable to have insured against the cost of experts' reports on the question of liability, but it would have been reasonable to insure against the cost of reports on causation, and then declined to apportion. So another point that was being taken against us was not just that it was unreasonable to take out right at the outset, but also you should wait to see what sort of reports you need, and that was rejected by the Court of Appeal. Then going to the judgment, the paragraph 24 to 26 is important in terms of this case-by-case assessment. So just put this in context. These are cost assessments in respect of these after-the-event insurance premiums under the regulations that are before your lordships. And an issue arose as to whether the Court of Appeal should have regard to Callaway & Gray, which was a pre-Jackson authority, pre-1st of April authority, but which was a seminal case on what is a reasonable and proportionate after-the-event insurance premium to incept, and on reasonableness as well. So both incurred and whether the particular sum was reasonable and proportionate. And our case was, for the claimants, that the Court of Appeal should be looking back at the jurisprudence that preceded the 1st of April to see the approach adopted by the Court of Appeal in respect of these premiums. There's no reason why it can't continue. The reason being is that this is a carve-out. So that what's happened here is that the law has prevented the recovery of AT premiums in some areas, but allowed its continuation in others. And it would be slightly unprincipled and odd if you couldn't refer back to this jurisprudence that dealt with the recovery of premiums where they remain recoverable. And the Court of Appeal agreed. The Court of Appeal said, we will continue to apply the guidance in Keller and Gray. And in Keller and Gray it was said, you can take out these things right at the outset. Now, we say a similar approach should be taken in connection with the sort of Rogers type arguments, and paragraph 26 of McMenemy applies equally here. It's clear that the Court of Appeal in Keller and Gray, and as upheld eventually in the Supreme Court, the House of Lords, was seeking to arrive at a point that meant that these arguments about whether an insurance policy was taken out reasonably or not were not determined on a case-by-case basis. That it was going to rid a whole load of litigation that would otherwise arise. And 26 amplifies that. It's clear that the departure from the usual case-by-case assessment of costs was deliberate on the part of this court and upheld by the House of Lords, despite serious reservations by Lord Hoffman and a powerful dissent by Lord Scott. In effect, therefore, the question was settled at a macro level by reference to the general run of cases and the macroeconomics of the AT insurance market, and not by reference to the facts of any specific case. Now, the reason I raise that before your lordships is this. When we were helpfully discussing where it all may end up this morning, one solution is to say, and we say, that the premium here is proportionate. It's been examined in detail. They've got nowhere with that. And for this court to say, look, rather than having an assessment on every single case, your lordships may be content to say we're going to take the same approach as been taken hitherto in this market in respect to these sorts of costs, that from a macro point of view, we allow the recovery of these premiums in all cases. They're reasonably incepted at the outset. They're judged to be proportionate and reasonable given the evidence that we've received to date. That may change, open brackets, in the future if some expert comes along and says it's all getting too excessive, which close brackets. And so that there is this macro approach to the recovery of the premiums, which has hitherto worked. It worked in Keller and Gray, it's worked in Rogers, and McMenemy has applied that approach to the inception of the premium Prince point, and we say we should continue to apply it in the context of whether it was proportionate. Well, you are going to get cases where the damages are less than the premium, but you're going to get cases where the damage is a lot more than the premium. I keep saying that, but there comes a point when the court will be exhausted. And one option is to take this pragmatic approach and say, look, at a macro level, taking into account the industry and the underwriting book and block rating policy and so on, it's better actually to just say they're proportionate. So they're isolated, a bit like a court fee. So that when you come to do...
But there are two different issues here.
Yeah.
And you've made the case in a sustained way, by reference to a number of different documents, for saying that when you're looking at the individual items on the bill, and you're looking and saying, taken on its own as an individual item, is this one necessarily too reasonable, and therefore three proportionate? That's one thing. But you've still got the position at the end of the day, which must be contemplated by 44.32a, because it contemplates that there is a situation where costs are both necessary and reasonably incurred, but they are still disproportionate. So there must be a setting where that applies.
Yes.
So what one's got to work out is, well, in what circumstances can that apply? In what circumstances can costs be both necessary and reasonable, but disproportionate? Because such a situation is envisaged by Parliament.
Yes.
Whatever this case says. And you haven't really helped us on that.
Well,
because all you do, and you keep on coming back to the same point and saying, yes, but once we've satisfied the court that the premium was necessary, taking into account everything, and there wasn't a better premium out there, and once we've satisfied the court that it's necessary to have it, as is contemplated by the rules in Parliament, that you need an AT premium in order to have access to justice, you say that's the end of the matter. But if that was true for every single item of costs, then the statutory understanding that you can have a situation where all costs that are left are necessary and reasonable, but not proportionate in all the circumstances, it still applies. You haven't explained that.
Well, I think it turns on the description that I just gave about if it applies to every single item of costs. We're quite careful because I'm not saying we're here concerned with a premium, which is not set by reference to the facts of the case. It's set by the market by reference to the insurer's basket of cases, taking into account the policy. So it's not like an item of cost that can be reduced even if it's necessary and reasonable. If it appeared to be disproportionate, I accept the court, if it considers it to be disproportionate, can reduce it. That's what the rules say.
Disproportionate to what?
Well, they're the factors in 44.3.5, 44.2.5, the list of. So we can turn to them. It's quite a.
I thought you were saying that 44.3.5, I thought was part of your case, is not the last end and the last word on it because 44.4 says it's all circumstances.
It's all the circumstances.
So they're not 44.35 isn't the end of the world.
It's not.
Yeah, right.
No, but when it's not the end of the world, but when we're told by 44.3.5 that costs incurred are proportionate if they bear a reasonable relationship to the sums at issue in the proceedings, the value of any non-monetary relief, the complexity of litigation, additional work generated by the conduct, and the wider factors. Now, what our submission really boils down to is that given what we know about the premium and how it's been rated and what the assessors have said about it and so on, even though it may exceed, quotes, the sums in issue in the proceedings, doesn't mean it's disproportionate. I accept that if the court concludes that it's disproportionate, it has to be disallowed. I mean, that's what the rules say.
You're not answering my question. I'm sorry to press it. You're not. My question to you is quite a simple one, which is, let's assume, I think you're encouraging us to follow this line, that what the cost judges should be doing is taking each item and ideally going through it once, looking at each item and saying, is this necessary, is this reasonable, is this proportionate? I think at one point you said you wouldn't welcome going back to it again.
You don't need to do reasonableness. So no. So the approach is not. There are two ways of doing it. One way is to look at the individual items and decide what is reasonable. Ignore proportionality altogether. Just what is reasonable. That was the approach that Lord Justice Jackson had in mind, it seems from his report. And then at the end you stand back and say, is that figure proportionate? And when you did that, if you adopt that course, we would say that in the context of the premium, you would take into account all of the circumstances, including the wider economic circumstances and so on, evidence that you have about comparables, if any, the report here of the assessor and say, this isn't disproportionate. That can be part. That's isolated. The other items I look at again, there may be work on witness statements or work on counsel's fees or something, where I do say, actually, I do think they could be reduced still further to reflect proportionality, and you arrive at a figure based on that kind of approach. That's one approach. And there, what you're really saying in that...
Why, if there was somebody from the Law Society here, they would say, well, that's not right. Well, if the total amount is disproportionate, then there should be a discretion to reduce everything across the board. Yeah, but then you fall into the trap of the example I gave earlier about the defendant's conduct. That would be wrong, because you can have costs that are caused by the defendant, which the judge makes a finding about. That happens a lot, where costs are incurred because of conduct on the other side. The 8-9 examples given of the interlocutory hearings.
But that's the easy answer.
That's it.
Take the position where we follow, the approach follows the line you're advancing in relation to premiums. It's block rated, it's proportionate, therefore, even though it produces a result that's seemingly surprising in the instant case, because of the volumes. Then you look at the individual proportionality of what was done by the lawyers. Let's suppose you think, well, case by case, that also is proportionate, because, and you let's ignore the 9 interlocutory hearings for the moment.
Yes.
And then you stand back and you say, but overall, the cost of this case is disproportionate to the outcome. Take everything together. We've allowed that. We think there's nothing individually disproportionate about this or that or the other, but overall it's disproportionate. If you have put a ring fence around the ATE premiums, the only meaningful way of producing an overall figure which appears proportionate is to reduce the other costs, and that will hit the lawyers.
Yes, but I'm not suggesting that approach is adopted, because in your example, you're assuming that there's been a decision made on proportionality. So you're saying that it's proportionate on an item by item. Then I think you wouldn't have the second stand back, because you've already counted it, you take into account proportionality, and you couldn't stand back.
Well, that's what I was trying to tease out.
Yes.
I think my Lord's point is that you need to be able to stand.
So if that's right, you couldn't deal with proportionality on an item by item basis. You could only look at that at the end globally. Then you could say, globally it's disproportionate.
Yeah.
But my submission there is that, well, I now have to apply some reasoned approach here to how do I get that bill down to a proportionate level. I look at what I've allowed. I've allowed a premium. I ask myself, is that premium, is there anything in that premium that justifies a further reduction on grounds of proportionality? And it depends. If we're in the world we're in here, we would say no. Is there any justification for reducing the profit costs or the barrister's fees or the expert's fees? There may not be. There may be. There may not be. And if there is, then you can do so. You could do so with a premium if there was reason to do so.
The trouble is, the hypothesis I don't think there's a problem with the way you're approaching this on the basis of you look at each item and see whether it's reasonable and necessary. That you go through that. Is it reasonable? Is it necessary? You then look at the overall result and you say, it doesn't look to me as though this is very proportionate. Then you have to find a way of making it proportionate. That's what we have to do. And that's where the DJ wants some, cost judge wants some guidance. You say, well, before you undertake that exercise, what you do is you take out of the equation completely one item, and that's the AT insurance.
There might be more. I would take out fixed costs that are unavoidable.
Or fixed costs, or whatever it may be. You take out that, you take out fixed costs, and the AT insurance, as everyone otherwise
take out the VAT, the insure fees, anything that was critical or essential to the case would come out.
And what I'm saying is, that's all very well. And of course, then you can go and you can say, well, that everything else appears to be, let's see if we can reduce the other. But you may still end up, if you don't reduce, you may end up at the end of the day disproportionately casting onto one particular category, namely the fee earners, the burden of reducing the thing to proportion. That's what it comes to at the end of the day. I mean, is there any authority? Is there any authority that, let's just take an easy example, court costs. Are you saying, and you may be saying this, in no circumstances would a cost judge ever take those into account in working out what's proportionate at the end of the day? They wouldn't reduce those.
We'll come to the authorities. There's 2 or 3 cases where the cost judges have taken out. When I say taken out, they've left those as recoverable in full.
Right. Is that the standard practice?
I'm not sure what the standard practice is. I mean, the problem is I think, in fairness to everybody in court, I think there is a degree of different approaches being taken. But certainly, most recently, we can look at His Honour Judge Dyte in May, which was an appeal case. He took out the issue fee. The
Andrew Smith, tab 30, page 15.
the addition
It sounds
to
as
your,
though at the end of the day, because you're making an analogy, you're saying here that the ATE insurance premium, I'm not saying you're not necessarily wrong, I'm trying to test your case. You're saying that the ATE insurance premium is to be regarded in the same way as, for example, an issue fee. That's what you're really saying.
yes.
When it comes to proportionality, that this is to be regarded in the same way as an issue fee, and there may be other examples, I don't know, that's the obvious example, because you say you can't litigate without that. That's the reality of the matter.
Yes.
There is a slight difference because, you could in fact litigate without an AT insurance, but you say it's not practical.
Yes.
to do that. I mean, it's actually not possible to litigate without an issue fee. That's not, although you might get it remitted, you might get the cost remitted, but I mean, subject to that, you have to pay that. It's not a choice, whereas you do actually have a choice with taking an AT insurance. You could self-insure, or whatever it may be, you can take the risk on yourself. But you say it's of a different category because it's there to provide access to justice.
Yes, we do.
But I think if there was somebody from the Law Society standing there, they might say, yes, but everything this solicitor has done was actually essential. They had to do this. They had to do that.
But if they did, they would probably convince the cost judge. Sorry to interrupt, but they would probably convince the master that actually it's not to be reduced on proportionality grounds, because it may be, but it's a powerful argument to say that it shouldn't be.
But then I come back to the problem with that is if you take that to its logical extension, you will never get to a situation where, as envisaged by Parliament and intentionally, in order to confine costs to what is proportionate, you'd never get to a situation where costs are necessarily incurred and reasonably incurred, but they are disproportionate. That's the problem, because at each stage you go through, if you isolate each category and you're satisfied it was reasonable and satisfied it was necessary,
I'm not sure that's right.
You never get to a situation where you could have find that's my problem.
Well, there may well be. I'm not saying in this case no, but certainly I'm not saying that a court might still find that what a solicitor did or what a barrister or an expert did was necessary, but still disallowed on the grounds of proportionality. The rules. It depends. I mean, but our approach doesn't prevent that from happening. That can still happen.
Surely that's not the point. Of course the court can say, well, this action or that action is unexplained by the complexity of litigation or by something the other side did. What we're talking about is you can't fix any particular thing with being a disproportionate action. Obviously it's reasonable and necessary, otherwise we wouldn't be thinking about proportionality. But at the end, if the result is that you stand back and you say £150,000 has been spent to recover 7,320, your analysis does not allow the cost judge on any basis to say I'm disallowing the costs, which item by item are necessary, reasonable and proportionate. There's no overall proportionality judgment. That's what you're saying.
There's an overall proportionality judgment, but it's tied back to a reasoned view about what is being reduced. What I'm absolutely submitting is that what you can't do is just simply say £157,000 was the costs, £7,500 was the damages. I've arrived at a figure of £120,000 being the recoverable, the reasonable cost. I'm going to now reduce that to 5,000. That would be, but what he can do, what the court can do, is reflect on the decision on reasonableness, and reduce those costs to reflect proportionality. But if every single cost was necessary, it may well be unlikely that much will come off on proportionality grounds. I mean, I accept that's where my submission sort of ends up, but that's not to say that you couldn't. The rules say, they make it very clear, you can reduce on the grounds of proportionality, even necessary costs. I accept that can happen, but it may be quite rare.
You could say, you haven't yet said this, you could say, well, the reason it should fall on the, basically on the profit earners is because they've made the decision that the case should continue to take it on, and therefore they should bear the brunt if at the end of the day it's turned out to be disproportionate. If you haven't said that, I mean, that would be a logical submission to make.
I think that partly boils down to what...
Make a very popular person.
No, but I'm not going to... But I think that's another way of putting it, isn't it? That what they did was not necessary. You see, if they've pursued the case in an we got to the bare bones of a case where such are the figures in the example we're hypothesising on, that we're getting to the point where every single item has to be considered to be necessary.
But that's because you.
Then we've got to pretty unusual case.
That's because I can go back to the same point. So again, that's because Parliament has envisaged that there are costs which are necessary and reasonable, but are disproportionate. The logic of your position is it's difficult to envisage where that could ever be so.
Well, let me just raise this as well. Where that addition comes in on Rule 44.3.2a, costs which are disproportionate in amount may be disallowed. Now, that's the use of the word disproportionate amount is different from
44.3.2a.
correct. So the principal rule 44.3.2a is that the court will only allow costs which are proportionate to the matters in issue. Right now, the matters in issue will draw in obviously sub-rule 5. Costs which are disproportionate in amount may be disallowed or reduced. Now, it's not the language there refers to amount rather than to matters in issue. I think what the rule maker is saying is that you might get an amount which appears disproportionate to the total damages, for example, but still find it's not disproportionate if it's proportionate to the matters in issue. That is an argument which...
That would be to say that the definitions in 44.3.5 don't apply to...
I will be the first to accept. I will be the first to accept that I doubt the drafters of this rule anticipated things of that kind, because you know, at the end of the day, it's disproportionate to the amount. Maybe the same thing as saying.
I think you're on stronger ground myself if you say that there is a qualitative difference between work which has a human factor to it of, as it were, judgment about the case and advancing it on the one hand, and a situation where something is a fixed figure which can't be influenced by any element of judgment. I think you've got to, that seems to be something along those lines. Is you've got to make if you're going to isolate one factor in this way, you've got to make a qualitative difference between that and everything else.
But that's exactly that is what we are saying. I mean, my lord puts it in a way, but my case throughout in writing and this morning has been that the premium is effectively a fixed cost. It doesn't go up or down as the case goes on. It is a fixed figure, like an issue fee. It's not the same, I accept that, but it's analogous to it. And if there is scope, which we submit there should be scope for a court to say an issue fee can never really be disproportionate. We're getting in a world of, I mean, that would be quite an extraordinary outcome. It may be your lordships disagree, but we would submit that an issue fee, which is a critical fee to incur to bring a claim, can never be disproportionate expense. It's
Mr. Kyne's going to burst to this you talk.
right. If you would excuse me for one moment.
That's exactly what Andrew Smith does. Where's your proposition? He does it. He deals with the VAT and the costs of the bill. Both of those are not decisions made by the fee. They're the ones that are.
Could you get the reference to the?
It's page 15, tab 30.
Yeah. So the maker.
And I'll do that.
So, two examples of this approach.
Page 15.
The first one is decision of Mr. Justice Smith, which was only last week.
This is examples of the
Isolating.
I was going to say,
He didn't isolate the issue fee.
Ring fencing point.
Ring fencing point.
So this is tab.
Tab 30. We want the makers because he did do. He issued.
Oh, yeah, start with this.
Paragraph 60.
Paragraph, page 15 of the judgment, paragraph 59, 60.
So this is Malmsten.
Correct. And there are
Paragraph
59 and 60.
Did you say tab 13?
30. 30. 30.
30.
Sorry. I mean, VAT was excluded, and that
Hang on a
was
minute,
obviously
I just-
for that.
I've not looked at this because this only
No.
came to me this morning, but I noticed that his paragraphs 56 and 57 assume that lounge is gone.
Yes, it does.
Yeah, and then you were taking us to 59.
59 and 60. So what the judge does is he excludes from the consideration VAT and the cost of drawing the bill of costs. There was a challenge to that on the grounds of appeal. Judge says Marston was entirely right to leave VAT and the cost of drawing the bill out of the account when it's going to put present. these are no more than distorting factors when considering overall proportionality of the costs. The fact is that when consideration of proportionality, one is seeking to determine whether there's a proper or proportionate relationship between the overall costs and the action or the application giving rise to these costs. Self-evidently, the costs of any detailed assessment, which are costs entirely unrelated to the nature of the action or application whose costs are being assessed, must be left out of account. Now, and equally VAT confuses rather than assists. It's not an AT insurance premium. It's not, in that case, the issue fee. It is in the May case. But what the court is saying, that leaving out of account costs which are unrelated to the nature of the action or application makes sense. Now, of course, I accept an ATE insurance policy is related to the action because it's taken out in respect of it. But it bears a resemblance in the sense that it's a one-off fee, payable in all cases, and
Well, maybe the test is that in 61, an inevitable cost to the receiving
inevitable cost to
party.
receiving party.
Now, you would say, this may be where the difference lies between you, so you would say that it's inevitable cost because nobody's going to litigate these PI cases without taking out an AT insurance policy. But actually it's not an inevitable cost because you could still litigate without an AT policy.
Well, you can't.
You're not compelled to take one out.
You're not compelled to take one out, but certainly the policy of the Act, the policy of the regulations and of government is that that we can look at the explanatory notes to the regulations. They're designed to provide access to justice to
I appreciate that.
litigants who can't afford to litigate their low-value claims in particular.
Yes.
So if you've got a £4,500 claim,
No, I understand that.
so
But they're not-
you're
but they're
forced
not-
in a practical sense to take it out. From a practical point of view,
Because you can't initiate the claim.
you're required to take it out. Nobody would.
It's to the benefit of the defendants here because if a policy exists,
They call on it.
then they get the
They call on the policy, yes.
Well, with respect, that's completely incorrect because post-April 2013, what we're talking
No,
about
they
is
were-
the claimant's own cover for their own expert reports. It provides us with no cover for adverse costs.
Yeah, but they still
Post-April 2013.
the underlying policy does, as you know from the assessor's report. And from McMenemy, the policies ensure the adverse cost risks associated with quox that's left over, so Part 36 risks and so on. They ensure those. The claimant pays for the cost of that out of their own damages, but certainly the defendant will call, or that policy will respond to a call on behalf of the defendant if they have a cost order in their favour. Absolutely.
So do you think, therefore, that we can reduce this part of the analysis, are you content with this, that we should reduce it to the question of when carrying out the proportionality exercise, having gone through a reasonableness exercise in relation to each item, that the reason why there should be a ring fencing of the AT insurance when it's deemed to be necessary and reasonable is because it is to be treated as in the same category as any other cost, which, using these words, is an inevitable cost.
Yes, and
to receive
unavoidable.
party. Is that what this is reduced to?
I think it is, my lord. Yes.
Because that's a kind of a simple
it is.
issue.
I mean, we see another example of it in the case behind tab 20, the Brian May case, where the lead guitarist of Queen was involved in some litigation regarding some noise caused by one of these super basements in London, and
This is when the bench doesn't ask who are Queen.
yes, the Gaza,
You
yes.
have to remember they are being live streamed.
Now, paragraph 72, 72, 70,
72.
so paragraph 71 to start with, and then 72. I will come back to other parts of this if I need to later, but on this particular topic, I've dealt with the question raised by ground 4 and how the court should take account of the factors once weight has been given to them earlier in the section. The search ultimately to be undertaken by the cost judges for the figure which bears a reasonable relationship to the 5 factors of the new rule, having regard to all the circumstances. this would be a holistic approach and may be done as an item, the item by item assessment procedure, or as a separate and subsequent stage. So that's the two options. However, I doubt, for the reasons given above, that the proper interpretation of the rules requires, or indeed entitles the cost judge at the end of an item by item assessment to impose a very substantial reduction on the overall figure without regard to the component parts. In other words, you can't just say, boof, 50,000 is proportionate. I reiterate what the rules require the judgment to achieve is a balance, a reasonable relation in correlation which may necessitate a certain amount of fine-tuning. There may be a limited range of acceptable difference in the total figure once the rules have been applied, in that different judges could legitimately come to slightly different conclusions as to the proportionate sum. So long as they have applied the rules correctly, they should not be open to challenge on appeal. However, the final figure in this case does not appear to be based on any specific mathematical calculation, nor is there a specific explanation of how the weighting of the various factors resulted in the final figure. And in the conclusion, towards the end of that passage at paragraph 72, there's a passage that starts, we have revisited the elements of the bill. So they've gone through what's allowed as part of the reasonableness test. We have revisited the elements of the bill and take the following approach, having regard to our view of the factors, including the factors which were not challenged before us. First, we would not reduce the court fees or costs of drawing the bill. So there was another one. And secondly, we would apply a smaller reduction to the experts' fees than we would to the profit costs, reflecting our view of the essential part played by the expert evidence. That's another essential part played by the expert evidence. So there you can see my approach bearing fruit in terms of where the court considers that the court fees they are incurred come what may, so to speak. They're unavoidable. They're taken out of account. And even where there was an essential part played by the experts, this court in May took the view that they should suffer less of a reduction than the other costs. So
That's a different point.
It's a different point.
Because the court fees are ring-fenced on this
Correct,
analysis.
they're different.
The experts' fees are subject to the rules of proportionality, but they come to a different view than the reduction below because they say it needs to emphasise the essential part play.
Right.
So that, in that sense, that goes to quantum rather than principle.
It does, I agree. But what it does demonstrate, it demonstrates what I was seeking to submit earlier, that there does need to be this reflective, principled approach to proportionality at the end. And it might.
We've gone beyond.
We've got that.
We've gone beyond that point.
We have.
We're trying to find a principled basis for ring-fencing the AT insurance premium. That's what we're concentrating on.
Yeah.
And I think you do it on the basis, rightly or wrongly, if you hear Mr. Manager on this, that they are of the same nature as court fees, cost of drawing the bill, VAT. Right, is that it?
Well, what I was going to do was it's a matter of your worship, but what I was there's a whole load of cases in here about reasonableness, about the correct approach to take when challenging a premium. So this is the West reasonableness issue. That starting with Chris Motors, that you need expert evidence, reflecting really upon what Rogers has said, what the Court of Appeal in Rogers has said, that cost. Now, I might just refer to a couple of those, if I may. There's a decision at tab 14, which is a recent decision of Mr. Justice Stewart, who knows something about legal costs. Not that that makes a difference, but on the 8th of March, this case of Murray.
So this is tab
14. And this was about an ATE premium. It's not a clinical negligence premium. It was a follow-on case from the earlier regime.
So it's not clinical negligence.
It's not.
So it wouldn't now be recovered, but it was because of when it started.
Yes, and it's about reasonableness and about the ability of the court. Ground 2, paragraph 45, page 190 of the judgment. It's applying disproportionate under the old regime. I'm just trying to find the date when the premium was taken out. I think it was.
What is the passage you want to refer us to?
Let's have a check. I think it was. So it was paragraph 45, 46. So there's a £50,000 premium. The judge goes through the Deputy Master's decision in respect of the premium, and paragraph 48 sets out the criticisms to be dealt with. The premium was completely disproportionate, being 432% of the risks. The premium was disproportionate because it wasn't staged. Too much weight was placed on the evidential burden citing Chris Motors. The defendant, paragraph 50, the defendant says that on the factual matrix it was not possible for the defendant to produce comparators due to the antiquity of the premium and the fact that RAC are not a mainstream AT provider. Paragraph 54C, it must not be forgotten that this premium was a block rated at 90%. It was not a bespoke policy. There was no evidence before the court upon which to deconstruct the approach to the premium. Paragraph 54C. And in the end, the judge upholds the claim for the premium in full. So it's a recognition that certainly with respect to the block rated premiums, Mr. Justice Stewart accepted that without evidence upon which you can deconstruct the premium, there's some difficulty in interposing one's own view about what might be a reasonable premium. Similarly, in the authority prior to that, tab 13.
So what are you relying on here?
Well, I'm just wondering whether we Percy.
There was no evidence before the court which to deconstruct the approach to the premium. Is that the point?
Yes, that's right.
That's
Right. That's the key point.
Do we want to refer to Percy? Yes.
Probably. I was going to refer to Percy, but I know that that's, I think, pending in this court. So it may be
13.
Tab 13, which is a case called Percy.
I mean, speaking for myself, and you can correct me if I'm wrong, but a number of the first instance decisions seem to suggest slightly different conclusions.
Yes.
And then some of the later first instance decisions loyally try and steer a path through them. But
Yes.
speaking for myself, I'm not persuaded that it's a helpful guidance to try and differentiate between cases where the district judge thought that the premium might be too high, or the case where they thought that the underwriting might be flawed, because the district judge isn't necessarily going to know which is which.
Yes, that's a fair. I think that's a fair. I mean, one's always got to be careful about referring to cases about different premiums and different. I mean, but we're not, a lot of these, some of these cases are not clinical negligence premiums where we have the same policy arguments to underpin our submissions. But in the case of, I think probably Belcher's, let me just check. So the case behind tab 18, again, it's a decision of a circuit judge in Leeds in respect of an Allianz premium. The reason I refer to this is it is a case under the regulations. It's a premium of 3,843 for Allianz, so it's a similar premium. And again, the same It was against the hospital trust, so Mr Mallew was instructed in respect to that to challenge the premium. And Allianz, paragraph 6 of the judgment, do you have it? Tab 18. They have a similar, they have operate a block rated policy, paragraph 6. And Mr Mallew was submitting at paragraph 9 that it wasn't necessary for a defendant to put forward underwriting evidence. It's sufficient to just raise a prima facie challenge. And then under the heading, was the amount of the premium reasonable, paragraph 14, there was a reference to the defendant having provided the district judge with evidence from LAMP. Again, they're the two from LAMP, £9,000 indemnities. Referred to the case called Noakes, where Master Leonard didn't have any truck with those sorts of comparables. Paragraph 17, as in the incident case, Master Leonard had the LAMP policy presented to him in the Noakes case. Mr Mallew at paragraph 21 was submitting that all that's necessary is that there must be some material before the court, some sound basis for the court to see a prima facie challenge to the reasonableness of the premium. And then paragraph 27, whilst I recognise that this is a low value clinical negligence case, it is a case in which a detailed assessment was ordered. The mere fact that it is a low value claim is not in my judgment sufficient to establish that the district judge can simply take a broad brush to the premium amount. I reject Mr Mallew's submission to that effect. In the light of Master Leonard's decision in Noakes, I've come to the conclusion that the challenge on the face of the papers in this case is in reality an underwriting challenge. Whilst I accept the challenges on grounds of reasonableness may be brought where appropriate without the benefit of expert evidence, in my judgment the challenge on in this case, based on the level of indemnity in the context of the block rated premium, the level of indemnity provided across all bands, and by comparison with the bespoke single premium policies, amounts to a challenge on the basis of underwriting calculation. To cast it any other light would amount to a challenge to the choice of use of block rated premium policy per se. And as Mr Mallew accepted, that he could not argue that the AT premium was unreasonably incurred. At its highest, in my judgment, the defendant's challenge amounts to no more than a simple assertion that the level of indemnity looks too high. And then under the heading of was an AT proportionate, paragraph 30, this is a wholly separate consideration from the question of whether the premium was charged was reasonable. Yeah. The real issue, paragraph 32, between the parties in relation to this matter is whether the question of proportionality applies to the cost figure for the case as a whole as opposed to individual cost items, specifically in this case the AT insurance premium. Mr Jameson submitted that the issue of proportionality can only arise at the end of the cost assessment. It relates only to the cost figure for the case as a whole, after any reductions for expenses not reasonably incurred or not reasonable amount. Mr Mallew submitted that there's nothing in the wording of the rules to preclude the court assessing the issue of proportionality in relation to individual items. Perfectly entitled to conclude within the ambit of his question that it was not proportionate to spend nearly £4,000 on AT premiums for this low value clinical negligence case. And there was reference to the Noakes case again. Paragraph 35, Mr Mallew submitted there's nothing in the rules to indicate that proportionality cannot apply to individual items. In my judgment of paragraph 37, even if costs are proportionate overall, it could still be the case that an individual item of cost is disproportionate. By way of illustration, suppose that in a particular case there's a very low fee for an expert's report, but in the same case the costs of physiotherapy treatment are set at the very highest possible level. Looking at the costs as a whole, it's possible that they could be considered proportionate because the very high cost of physiotherapy treatment has been offset by the very low fee for the expert report. In my judgment, it would be entirely appropriate in that situation for the court to consider whether the physiotherapy was a cost in fact proportionate in the context of the criteria under 4435. recognising in principle I've postulated in reality is unlikely that the physiotherapy treatment cost would have passed the test of being reasonable in amount if they are significantly higher than the market rate. Nevertheless, the example is in my judgment relevant to show that there may well be cases where proportionality is relevant to individual items, not simply to the bill of costs as a whole. The two are not mutually exclusive. It will generally be the case that a particularly high charge or a particular service is likely to be both unreasonable in amount and disproportionate. However, the converse is not true, and the rule makers makes it clear that just because an item of expenditure is reasonable in amount does not necessarily mean it's proportionate. And then he refers to district judge's decision. It's paragraph 41. It's clear that the district judge well understood his provisional assessment on the basis of the evidence that there were products available on more advantageous terms. It was based on comparative premiums for a different type of insurance product and is not block rated. Mr. Mallow submitted that having made clear that he understood the difference in those products, the district judge nevertheless decided that the lamp comparables policy provided at least some evidence about other premiums that were out there and available in the market. He submitted the district judge's reasoning from 936 shows that plainly the judge properly considered those matters. This is really the case that's being argued against me in this case. 45, Mr. Mallow submitted in those lines that the district judge was plainly considering the issues of proportionality. Accept that submission. In my judgment, the district judge has found in effect that it was open to the claimant to bring the claim under using a cheaper insurance product. That decision was made in the context of proportionality, not in the context of whether the premium charge was reasonable amount for a block rated policy. The latter would, as I've found, have required either expert evidence or evidence of premiums in other block rated policies before the district judge could have made further inquiry into that issue. However, I do not consider the same is true when the district judge was exercising discretion in relation to proportionality. In my judgment, the district judge was entitled to exercise discretion the way he did, and was well within the ambit of his reasonable discretion in doing so. It would not be open to me on appeal to interfere with that exercise discretion, in my thought it was appropriate to do so. I'm conscious that the use of proportionality this way could be said to undermine the principle that the use of block rated policies cannot be said to be unreasonable. However, that is the result of the amended rules and the express difference between the issue as to whether a cost is reasonable and necessarily incurred and the issue as to whether the costs are proportionate. Although it would be wrong, in my judgment, it would be wrong to compare the two different types of policy for the purpose of looking at the reasonableness of cost. The two different types of policy can be looked at when considering whether a particular case is proportionate. Now, this is the authority, obviously, my learned friend seeks to rely upon. We say this cannot be right. That here you've got effectively two completely different competing avenues being developed by the court, under reasonableness on the one hand and proportionality on the other, where the starting point is that the policy itself is not available. And to apply proportionality by reference to a policy premium that isn't actually available is unprincipled.
Like our case.
Yes.
Yes, but in that case, district judge obviously thought that even though a premium could be both reasonable and necessary, it could still be reduced for being disproportionate.
Yes, he did.
Would you say that was wrong?
That's wrong.
In
Yes.
principle, because you say, certainly what we now know about from the assessors, you're saying it's actually analogous to a fixed fee.
Correct, yes. Yeah, that's what we say. But that's just to foreshadow the sort of approach that's still being taken. I mean, the way one reads it is one reads a skeleton that's...
But this does so. So, as I summarising the position now, I believe that what you're advocating, but please correct me if I'm wrong, what you're advocating is that the court goes through each item, assessing whether it's both necessary and reasonable. They can do that on the provisional assessment on the paper. They don't need to look at the overall figures at the end of the day, but they go through all of those on the provisional assessment. And then it's necessary to look at proportionality, I think this case is indicating, from two perspectives. One is the court still needs to go through each item one by one to see whether it's proportionate. And it also needs to look at the overall total as a whole to see if the overall amount is proportionate. Is that right? There are two exercises in the sense of proportionality. The judge here is saying you go through each item, but there's also the question about whether or not you take a global view. But even if you take a global view, you still have to reduce. You can only, as it were, bring it into line with proportionality by looking at each individual item. That's your point. You can't just say, okay, throw up our hands, it's disproportionate, we'll just reduce it by X%.
individualised more category of cost.
You still have to look, whether you're looking at it as a whole or not, you have to go through each individual item, seeing what would be proportional or disproportionate.
Well, not each of every single. It depends what one means by each and every item. I absolutely wish to avoid the proposition that was raised by Lord Justice Coulson, which is that we don't want to be in a position where second stage we go through every single item, as my Lord has just mentioned, and see if it's proportionate. Categories of costs, areas of expense need to be reviewed. I think otherwise it becomes unwieldy.
So you say you go through each item to see if reasonable. You
Correct.
That. Then when you look at proportionality, you look at those in categories of cost, i.e. expert evidence. Or
Yes,
whatever.
areas of cost, periods.
Disclosure.
Maybe there was a period in the case where the particular costs were higher than. There may be different ways of doing it, but certainly not, my lord, every item. That would be unwieldy. And
once.
You've done a reasonableness once.
Okay,
done a reasonableness once.
So you look at proportionality by reference to categories of cost, and then you look at the overall amount you arrive at
Yes.
to see if that is proportionate
Yes.
to by reference to the factors.
Yes.
Right, but you do not, you're saying, in carrying out either of those exercises in proportionality, looking at categories and the overall amount, you do not take into account the 18 premium. That is ring fenced.
Or any other item
Simple.
of cost that is
It's inevitable.
inevitable.
I think that's the word to use.
That's right.
So does that summarise?
It does, my
your
lord. Yes,
case,
it does.
as we put it.
Yes. Now it may be that I can save the other authorities for reply on.
Well, I think you could have saved that one for replying away.
Yes, on expert evidence and so on. We're content to. Well, so I think I can probably. I haven't been through the assessor's report yet, and I just wanted to identify a few passages. Maybe that it's not necessary to do so.
Well, I mean, haven't you dealt with that in your skeleton argument?
We have in our skeleton identified some key passages.
Yes. Well, I think we've got. I think we you know, you will have a right to reply.
I mean, it's the whole appeal is proceeding against the background that these assessors have not concluded that there's anything obviously wrong with this.
There's nothing better out there.
And quite, and that the approach they took to assessing risk and to putting in place the premiums, which was a complicated and detailed approach with people monitoring what was going on here in terms of the legislation and the rule changes, with what was going on in Germany in terms of setting the premiums and underwriters, arriving at a fair and reasonable figure to apply, with no profit actually being made in this current quarter, with Mr. Malley's clients not actually making any proposal in respect of what a different approach would have resulted in. Pretty important. There's never been a figure, apart from these 650 sort of approach. It's
Well, that's not Mr. Mallow.
It's not Mr. Mallow.
District judge. In this case,
well, no, in the point of dispute.
in this case, we've got £172. I think was the figure put forward.
Exactly, that's the figure I'm referring to.
So on one view, there could have been no entitlement beyond that. But anyway, that was the figure that was offered.
Right. So we'll look at your skeleton argument on that.
Yes, and it was. So you just bear with me 1 moment, Rolf. Yes, I think I can probably leave it now. There's some passages. I'll leave it for now and come back and reply if I need to on the report. Thank you, Lord. Unless there's anything else.
Yes. Right, Mr. Mallow. Thank you.
My Lord, thank you. My Lord, it may perhaps assist if I indicate the approach I intended to take in response to my learned friend, and then your Lordships may of course indicate if you'd like me to take a different course. So, my Lord, there are three, we say, important aspects of this case, where not just the parties before you, but the industry, for want of a better expression, generally, would benefit, we say, from guidance. Lord, the first is the question of reasonableness, which crops up in West. And there, the core question is this question of burden. What is a paying party required to provide to a court in order, to use the expression in my skeleton argument, to put the court on inquiry? As your Lordship will appreciate, these are standard basis costs assessments And the usual position in a standard basis cost assessment is that the benefit of any doubt as to the reasonableness or proportionality of any item is given to the paying party. But we accept on the present authorities that to get to that point, the defendant nevertheless has to effectively raise an issue. The court's not simply going to make a reduction unless it's satisfied that there is an issue before the court. And so the first point where there is a difference between the parties is what needs to be put before the court. Yes. Now we say in short, and I'll come to the detail of this, we say in short that is essentially a fact-dependent matter. There are a fact-dependent matter, my lord. There are a range of different possible arguments about all items of costs, including after the event insurance premiums. The argument in relation to the reasonableness and proportionality of an after the event insurance premium may come from any one of a different backgrounds and different set of facts. So
there's no guide on that submission. There's no guidance that we could give. So it's not a very important case at all.
Well, my lord, it is in that.
We could say it's all fact dependent, but I mean that's not adding very much.
Well, my lord, the concern that we have is this: essentially, what the claimants are seeking to do is persuade this court that at least where premiums are block rated, a challenge cannot be brought in the absence of expert evidence. And we say that that is simply wrong. That a paying party can identify a challenge in a number of ways, and that it need not be by way of expert evidence. And indeed, there's been considerable discussion about the assessor's report, but we've not been to it, and I'll take the lordships to it in a short while. But we will say that the fact-finding exercise that has been carried out by the assessors here, without the benefit of expert evidence, is itself an illustration of the way in which it can be plainly established that there are aspects of a premium which are either outside the scope of the regulations or otherwise unreasonable, without, as I say, expert evidence being required. But our prime concern on the first point is to deal with this suggestion that there is a threshold in any case.
You can't be going through you can't be going through in every single case the exercise that's gone through here with this assessor's report. I mean, that would be madness.
My lord, I agree with that, and that goes also to concern we have about a point raised by my lord, Lord Justice Irwin, and the question of control of these premiums. We do have a concern at the suggestion that the way to control these premiums is to have a periodic attack once every couple of years in relation to a particular insurer, where we have this sort of exercise carried out in front of a High Court judge or whoever it might be, in relation to a particular insurance model. We say that there is a far wider discretion open to judges, including by reference to comparators. So that is the evidence of other products available in the market, not necessarily to this claimant, because of course the nature of block rating is that the individual claimant is denied access to the wider market because of their solicitor's choice to tie themselves to a particular insurer. But we'd say that the fact that that solicitor has tied themselves in that way, thereby preventing their client from using other products, does not mean that the existence of other products in the market to other claimants is irrelevant to the question of the reasonableness and proportionality of the premium. So, sorry, my lord, I've rather gone off into my submission rather than...
A claimant has to investigate what relationships their solicitor has before they instruct them.
Lord, no, that's not what I said. What my client's position is. My client's position, as in these cases, is that if you have a situation where we can put before the court evidence that other claimants with similar cases have been able to insure that case against the similar risk, because of course the oddity is that unlike the pre-April 2013 market, where there was ATE across a whole wide range of possible cases, here the only recoverable ATE premiums relate to a very narrow category. They have to be clinical negligence cases. It has to be insuring against the cost of recovering reports in relation to liability and causation. So there's a very narrow category of insurance that's available here. If there is evidence before the court that other claimants have insured similar cases by way of policies being available to them with much lower premiums, we say that that is evidence which can put the court onto inquiry as to why this particular claimant is seeking to recover a substantially higher premium.
What evidence, though? The bits of paper?
Lord, yes. In this case, that was the...
That's where this went wrong.
Well,
Because there were bits of paper that ultimately it was a different policy.
well, my lord, they always were different policies. We never pretended that these were
So
correct
it's not a
policies.
comparator.
Well, my lord, it is in the sense that it is a product.
And they're bust anyway.
Well, my lord, that particular insurer, there are in fact a couple more comparators.
LAMP
in the
policies are
NHS.
the ones that your clients have been using.
Well, my lord,
I mean, they're the ones that are repeatedly referred to in the cases. They're a Gibraltar-based company and are now in liquidation. So, I mean, when you talk about evidence of comparators, we have to be clear. Speaking for myself, bits of paper that have premium figures on it, on the face of it, don't seem to me to be enough.
Well, my lord, I'll take your lordship to the detail if I may. Just dealing with the point in relation to LAMP. LAMP is, as your lordship will no doubt know, an insurer who provided insurance across a wide range of markets, and there's no evidence before this court as to why they have encountered financial difficulties, whether that's related to their clinical negligence book or others. We simply know that they were a Gibraltar-based insurer that has gone into an insolvency process. But they are a long established, before that, I think they came into this market in 2006, was the evidence. They're a long established insurance provider, which many solicitors, properly presumably exercising their obligations to their clients and fulfilling the conduct of business rules, considered was a reliable and appropriate insurer through which to place ATE cover in the clinical negligence market. So with respect, LAMP cannot, we would say, simply be dismissed on the basis that they've now gone into an insolvency process. And indeed before the assessors, no, it was never argued before the assessors that in some way the LAMP policies or the evidence that was being produced by Mr Cousins was irrelevant because LAMP were not a reasonable insurer for a party to use.
But there may not be a great deal of difference between everybody on this point, because, I mean, you say you don't need an expert, but you do have the benefit in this case, unusually, of this inquiry that's being conducted as a result of the direction that's been given. It's resulted in this assessor's report. Now, what that does give us, for the future, a starting point, and obviously all refers to particular parts of the report, but one of the factors that does appear to come out of the report is actually there's not a huge amount of, these policies are different, and it's not easy to say just because they have a slightly different premium that one's better than the other or whatever it may be. So I think what's being said to you is what you need to do is you need to bring along, if you want to challenge the reasonableness of an AT insurance policy in terms of proportionality compared to others, you'd need to have somebody who's sufficiently expert to say, I've compared those policies with these policies, and it is my expert view that in relation to all material terms, they are at least as good a policy as this one. That's all. That's what's being suggested. You need somebody to say that, not simply to say, well, the other, which you seem to be saying at the moment is, well, lots of solicitors seem to be using those people and they're cheaper.
Well, my lord, again,
it's a question of degree.
It is a question of degree. Nobody disputes that a challenge can be made. The question is, how do you get to the threshold of that challenge effectively having been made so that you return then to the conventional basis of assessment, which is it reasonable, is it not, and if there's a doubt, the benefit goes to the paying party. So the question is really that question.
Why is that onerous? Why would that be onerous for your clients to be able to do that, to say, bring before court to say, look, I'm an insurance expert, I've looked at these 2 or 3 different companies and the policies they provide, and there are these features of them, and I'm satisfied that those other policies, which have a cheaper premium, lower premium, are at least as cover at least as effective cover as this one. What is that difficult?
Well, the starting point of that is we would say that's simply unnecessary. The point about these policies and the premium schedules give a certain amount of information. Often the policies themselves behind them can be available, so the policy terms can be available. The court is able, as I say, this is a very narrow market. All we are dealing with here is the cost, not the cost of a wide range of insurance, but it's the same risk that is being insured against.
It has very wide implications, because now we know for certain that in the case of a block policy, the solicitor has to provide all its PR claims through that insurer. you're effectively saying that insurer should not be insured, that solicitor should not be insuring with those insurers.
Well, Lord,
That's what it really
there
comes
are
to.
two aspects to that. First, we have to be careful about the facts that have been found by the assessor below. As your lordship will have seen, in fact, the assessors found that that obligation is one that is honoured in the breach rather than the observance. They found that one of the solicitors here, in I think it was the Demouilpied case, did not consider themselves to be under any such obligation, and they found that in relation to LAMP, which was one of the three insurers that gave evidence, in relation to by far the solicitor who provided them by far with the largest volume of their book, which I think at one point was said to be about 50%, they were not under an obligation to provide all of their insurance in relation to this matter to LAMP. So, my lord, we have to be careful about that starting point, because it's always cited as one of the core parts of the claimant's argument, and it's one of the points that was considered in detail by the
Maybe
assessors
it's not in
their
every
fact-finding
case,
process.
maybe it's honoured more in the breach than not. But the fact of the matter is, it's not the client's fault in some of these cases, it's the fact that the solicitor has no choice. The court can't ignore that. And so a challenge, in some cases at any event, a challenge of the kind that you're suggesting, in the absence of expert evidence, is actually a challenge about the way the solicitor is advising its clients, which is quite a serious matter.
Well, my lord, the first point is, when it comes to incurring costs, it's not an adequate answer for a claimant to say, well, I acted reasonably because I just did what my solicitor said to me. That's been dealt with in other areas. For example, this court's decision in the case of Surrey quite recently about changes of funding. It's not good enough to say my solicitor advised me to swap from legal aid to a CFA, therefore that was reasonable. So the question of this, if it is on the solicitor's advice, the question of the solicitor's advice cannot excuse the question of the reasonableness of the choice in the first place. So, my lord, the second point is in relation again to this question of expert evidence. It's important in our submission to recall that
Is this still under one reasonableness West?
My lord, indeed, yes. In fact, this was really just meant to be part of my indicating the path I was going to take, but I seem to have become enmeshed in my submissions. But, so, my lord, in relation to this question of expert evidence, all we are saying in relation to this is that in order for us to satisfy the court that there is an issue worth investigating, it doesn't determine the outcome, it simply gets past the threshold of whether or not the court is going to go into the detail of considering the argument. So in relation to that threshold, all we are saying there is that the idea that expert evidence is either necessary, nor indeed in the majority of these cases a proportionate or reasonable step, is, we say, a fallacy.
You simply go back to the point where in case after case you present a schedule that says for the following 4 paragraphs of reasons we contest the fact that this level of premium is appropriate in this case, and then you throw the weight onto the claimant to introduce some sort of evidence against you. There's no generality of conclusion about the nature of the policy. Each cost judge is faced with cutting this Gordian knot. What sort of process is that?
Well, my lord, we say that there are ways to deal with this, but we say that is part of the process. This is a detailed assessment. There's no provision in the rules which says an ATE policy is subject to any different process of assessment.
Well, that's what this case is aimed at.
Well, my lord, indeed, and that's essentially what the claimant's case amounts to, both in effect on reasonableness and proportionality. But we say on reasonableness, if the court decides that we haven't, whether it's through expert evidence or otherwise, then of course the guillotine comes down and we don't get any further.
Yeah, but that's putting all of the burden, my lord's point is this, that's putting all the burden on the judge. You have a pro forma set of complaints about the costs that we've seen twice in these 2 appeals, that raise a whole series of points, a whole series of authorities, all couched in the same terms. That's all put forward to the judge. The claimant then has the burden, because you say, well, we've raised the point. The claimant then has the burden of dealing with that, and then ultimately the judge has to decide that, point after point, on a case-by-case basis, which all the authorities say is what you don't do.
Well, my lord, it depends, again, which comes back to the way in which I started this, it depends on the nature of the challenge. And if we can take it across a range of possibilities. So my learned friend accepts, for example, that AT premiums are not generally inviolable from the process of assessment. So if we start with a non-block rated premium, it seems generally to be accepted, and indeed there are authorities, first instance decisions in the bundle, including of the former senior cost judge, including of Mr Justice Aikenhead, dealing with cases, for example, in relation to a single policy, a bespoke policy, where the court can relatively simply accept that an issue has been raised, for example, the point about the AT insurer's rating of success, or the other one that is classically raised is whether or not the AT insurer overestimated the likely loss that it was exposed to, and therefore there are two prime factors to individual rated policies. It's the likely loss multiplied by the prospects of having to pay out on that loss. And if the paying party can indicate in relation to either of those that there's a prima facie argument that they're wrong, or that they're out of place, or they weren't reasonably evaluated, then it seems generally to be accepted that the court can engage on that inquiry. A point's been raised, the court will turn to the claimant and say, well, a point's there, what do you say about it? If I think the paying party's right, then I'll reduce it. If I think there's a doubt, I'll reduce it until I'm satisfied there's no doubt anymore. So to that extent, AT premiums are subject to the usual process of assessment. If we come then to block rated policies, now the question in relation to block rated policies is, we say, what is the nature of the challenge? And our position in relation to these cases has always been in relation to the comparators, that the purpose of the comparators was to raise the question of why has this claimant incurred a cost of X in circumstances where other claimants with similar cases incur a much lower cost. And we say that that is a question we are perfectly entitled to ask if we're going to be required to pay this cost, and the court is perfectly entitled to require an answer to. And if it's left in any doubt in relation to that, we are entitled to the benefit of it. Now that's we say at the high point is the purpose of the comparators in this case. There might be other challenges in a block rated premium case where, for example, we might say, well, in fact, this particular insurer isn't a properly regulated insurer, or we've seen this particular insurer's policy and it's a hold harmless policy where the claimant has to say, we will hold the insurer harmless against any loss. That might sound bizarre, but there were outside the field of clinical negligence a number of years ago a run of cases in the personal injury field where the solicitors advising the client to take out the policy held the insurers harmless against any loss under the policy. So there might be all sorts of reasons why we say by reference to the policy in this particular case, not by reference to comparators, but by reference to the policy in this case, we think this insurance is not worth the paper it's written on, or we think it doesn't give the cover that it pretends to give, and in all those circumstances, the attempt to reclaim a premium of X by reference to the cover that's being provided, there's a question as to whether that is in fact a reasonable sum to pay for this. There may be others where, and this is rarer than your lordships might think, where the challenge goes directly to the underwriting process. Not necessarily to the building blocks, and we'll come to this in relation to the assessor's report, but for example, a challenge to say no underwriter would approach this matter in the way that this underwriter has done. And we may be told in relation to that, well, if you're going to say that, you need an expert underwriter to say that that is not an approach that is open to any reasonable underwriter. But that is not, we say, what this case was, nor in fact is it the conventional challenge. And our concern is that what the claimants, we say, are seeking to do here is invite this court to impose a threshold which is basically to say in simple terms, block rated, you can't challenge without expert evidence. And we say it is more nuanced than that. If on the facts of the case, for example, the example I gave about the terms of the policy in a block rated case, you can identify a basis for challenge. That basis may not need expert evidence, and we should be entitled to bring it. And if we bring it, and the court satisfied that the challenge has been properly brought, the court is required to determine it.
Just picking out, I understand about a challenge by reference to a particular policy in a particular case, whether the policy is valid, for example, or maybe in relation to the underwriting process. But you started off by saying that, it's entirely normal to raise the point that another client, or another claimant, only incurred X by way of a policy as opposed to the policy in the case under review. But that more widely in cost disputes, that's a very unusual type of challenge. I mean, in the real world, people are arguing about costs. They don't say, oh, well, there's a firm of solicitors somewhere else who will do this for £20 an hour.
Lord, that's exactly what they say.
And it raises questions of confidentiality.
Sorry, Lord.
Somebody who's not a party to the case, why is their material being provided to a district judge at all?
Well, look, we would say in detailed assessments, that question, in fact, more often than not, it's dealt with in a less informal basis than in fact is being dealt with in these HE challenges. But the question, for example, of you instructed Solicitor X wants to charge you £400 or £500 an hour for this low value claimant clinical negligence case. Why is that reasonable or proportionate? One of the key factors the court will consider, particularly, for example, if there's an issue about instructing that firm in a particular area which is a more expensive area, for example.
You have guidance on that. There are rates and there are areas and there are hourly rates for particular areas, and you go to those. You don't look at individual cases. You don't say Mr. X down the road instructed some other firm of solicitors for a particular case.
No, and indeed we
That's the unusual thing here. You're using examples, albeit I noticed that they're redacted, which also potentially gives rise to an issue, but you're using individual documents from other cases. I just wonder about that whole process.
Well, my lord, we are doing that in part, of course, because we are essentially facing what we would say is effectively a higher threshold than has been imposed. We would, in fact, endorse the concept that in certain categories of challenges to HE premiums, in fact, as with most other challenges, for example, a challenge to experts' fees, where the judge on assessment might say, well, you want X amount for Mr. Smith, but I've seen lots of expert reports from orthopaedic surgeons. I've never seen anybody charge as much as Mr. Smith. Why is Mr. Smith reasonable? We would say at this first threshold level, indeed, there's certainly in relation to some HE arguments, it should be open to judges who are experienced in this area to say precisely that. This premium looks out of kilter to my experience.
Yeah, you'll deal with the authorities that suggest that isn't right in this particular field.
Well, my lord, I will. But as I say, we in that regard, what is sounded in the authorities, we say, is a note of caution. And we don't cavil against that note of caution, which is that in block-rated policies, the courts have to be careful before embarking on this inquiry. What we dispute and what we do cavil against is the idea that there is an unambiguous threshold which requires us to produce expert evidence.
So you accept the note of caution. So again, as my lord, the Master has put to you, it becomes a question of degree. You accept the caution, but you say they go too far.
My lord, yes, and indeed I think I started on this part of my, what was an introduction quite a while ago now, of this introduction to this part, by saying that our case is in fact that it is a matter of it depends on the facts, and indeed, to use the classic expression, it's a matter of fact and degree. What we cavil against is the imposition of a threshold which does not feature in the rules. So, my lord, that was a more lengthy introduction. I'll come to the authorities on that point shortly. So, my lord, in addition to that point, the second point that we say that it is important for guidance to be given on is the correct approach to proportionality. And in that regard, that falls really into two parts. The first is the approach to proportionality generally in the sense of procedure, and there have been a number of exchanges between the bench and the learned friend about questions such as is proportionality looked at individually, is it then looked back at again at the end, etc., etc. And I will deal with that. And the second aspect is then the application of proportionality to ATE premiums. Does it merit any different ATE premiums, and in particular block-rated ATE premiums? And does it merit any different approach in the context of an ATE premium? And the third aspect that we say the court will benefit, the parties more generally will benefit from guidance on, is in relation to the matters that are dealt with in the assessor's report. So these assessors, I think Lord Justice Irwin's description at the case management hearing was that this was an extraordinary and unusual case. And indeed, I think one of the points Lord Justice Irwin made to the parties on that occasion is that this isn't a process we want to be going through again. This was an opportunity to deal with this question of how the court should approach the assessment of AT premiums and what is and is not recoverable. And in those extraordinary and unusual circumstances, we had the fact-finding hearing. We have that, and the assessor's report raises a number of issues which we say this court can give guidance on as to aspects of these policies and these premiums which are or are not recoverable. So, my lord, those are the three areas that I seek to address. If I...
Well, you've dealt with the first one, haven't you?
my lord, I've not, as my lord Justice Coulson highlighted, I've not taken your lordships to the authorities which might be thought to challenge my submissions in a number of those areas, and it's appropriate that I do so and seek to explain to the court why those authorities do not stand in the way of the approach that I've advocated. My lord, before doing so, perhaps it is, well, it may be of assistance if I deal with the question of the assessor's report and what we say in relation to the assessor's report. And in that regard, your lordships have, it was described as an addendum, it's at the end of the Demouilpied skeleton. Internal pagination, page 17 of the Demouilpied skeleton argument. But it's of application generally across these cases. Simply a convenient place to place it. And your lordships, of course, will have read the assessor's report with care, and I simply want to highlight a number of issues in relation to it in a number of areas where we say this court can give guidance and where that guidance would be of benefit. Within it, I've given the references to the report, and I'll take your lordships to that as necessary. So, Lord, if I can start at the bottom of internal pagination, page 17, paragraph 5. This deals with a point that I dealt with a few moments ago in the course of exchanges with the bench. This is the question of solicitors' ties to firms of insurers. And the evidence in relation to it, as I say, was, and the relevant references are set out, that in relation to one of the firms of solicitors, Mr Demoulpied's solicitors, that firm did not adhere, apparently, to any contractual obligation to recommend ARAG's products in every case, and it would seem that they were not alone, is the reference that is, was the expression used by the assessors. And indeed, as your lordships will see, that firm of solicitors did not apparently consider that they were under any such obligation. I've already dealt with this point, but over the page, the main firm of solicitors which used the LAMP scheme, and indeed, as I say, at one stage was said to provide approximately 50% of the business to LAMP, were not apparently under any specific obligation to only use the LAMP policy. And that requirement overall, the assessors concluded, was one that would seem to be honoured more in the breach than the observance. None of that, my lords, having taken your lordship to that, detracts, I accept, from the point that certainly a number of insurers, if not all of them, impose this exclusivity requirement. But the reason that we say it is relevant is that the argument that is raised in relation to comparators by claimants is a relatively simple one. And it's the argument in this case. It is that any comparator that my client produces is not an appropriate comparator because it was not available to this claimant, because this claimant's solicitor had tied themselves to a particular provider. Therefore, there is no comparator we can produce which allows us to argue that there is at least a question to be asked as to the reasonableness of the cost of the policy that the particular claimant chose. That's the effect of the claimant's argument.
I would doubt that myself. I'm not sure they're saying it's not possible just because a solicitor is contractually bound in a particular case to send all their first injury cases to an AT premium to a certain insurer, that therefore you're precluded from making any challenge. I mean, if you had the correct, if you actually got to the threshold of saying there are other policies out there, with or without expert evidence, all that at the moment, and questions raised, you're quite right. I mean, the fact that the solicitors tie themselves is neither here nor there, so far as the defendant's concerned in terms of the cost that they have to bear.
Lord, yes. Well, Lord, that's our core starting point in relation to this. That if we produce a comparator, and it goes back to the nature of these cases again, to the limited nature of this market. So the one thing we can know at the start is that what is being insured against, at least in terms of the recoverable part of the premium, whatever else the policy might provide cover for, is cover against the risk of the claimant incurring a liability to pay for expert reports on liability and causation. So it's the same risk, and our position is simply in that regard, if we can identify other providers who prima facie are reputable providers, as LAMP was thought to be by all the claimants who use them for 10 years or so, 10 to 13 years, if they are catering to the same market, if they are providing a policy which appears to have been available to similar claimants in similar situations, but
if they appear to
be providing a policy which was available to similar claimants in similar situations, the fact that this claimant could not have used that policy because of the solicitor's tie does not render that evidence inadmissible or irrelevant.
Should it mean that the ATE premium actually paid is wholly irrecoverable? That seemed to be what you were arguing.
Lord, that's not what we're arguing. It's not been part of our case here that this premium is irrecoverable at all. This challenge is solely in relation to the quantum. Our concern here is simply to ensure that the premium we are being required to pay is a reasonable and proportionate sum, and we say no more in relation to the comparators that the existence of those comparators, even if not available to this claimant because of the tie, is sufficient to raise a question as to why we are being asked to pay more in this case than other claimants appear to be paying in similar circumstances in other cases.
That?
Well, Lord, where we go after that?
£172.
Well, Lord, £172 I have to accept was my client's original position. It's not a position that I was not to take.
There wasn't another position.
Sorry, Lord.
There wasn't another position.
Lord, at first instance, there wasn't.
There wasn't. There hasn't been another position.
Well, Lord, we are seeking
That's
to
why
uphold.
we keep coming back to this question of all the guidance. This was a case in which your client said the premium payable is £172. Yes. That was the position in front of the district judge. That was maintained when there was the oral hearing, and there was no change when it was in front of Judge Smith. So that remains the position.
My Lord, our position...
And that was plainly, I think you accept, unsustainable.
Well, my Lord, the position in front of His Honour Judge Smith was that we were seeking to uphold the decision of the judge below.
And as I understand it, that remains your position today.
No, Lord, that remains our position today. That was not the £172. That was, in relation to the West case, that a reduction was appropriate on the grounds of reasonableness, and in the Demoulpied case that it was appropriate on the grounds of proportionality, and they arrived at different figures. And I can see it might be a concern to the court that they've arrived at different figures. But what we were seeking to say, and what we still seek to say, is that once they were adequately on inquiry, once they were left with a doubt, as they both of them found themselves to be, as to the reasonableness or respectively the proportionality of these premiums, they had to resolve that in some way. And it is in the nature of assessment, and my Lord Justice Coulson in particular will no doubt have experience from cost budgeting, but it's in the nature of assessment generally that there is not necessarily a right answer to these questions.
No, but I'm trying to, can we just focus on this? The proposition you've made, which seems to be, being myself, a perfectly reasonable one, is if you do establish that there are other providers out there providing a policy which is of no less cover, and less qualitatively suitable cover at a lower premium, then that is a matter that's relevant to the assessment of proportionality, whether or not the claimant could in fact take advantage of it because of the time of the solicitor. That's a proposition. It seems to me at the moment to be a reasonable proposition. I'm not sure we've heard any oral argument to the contrary, but no doubt in reply if there is, it can be said. What's your next proposition?
Well, Lord, perhaps then if I can come back to the assessor's report and the note in relation to the assessor's report. So, Lord, the second issue that we highlight, which in relation to the assessor's report, is the assessor's findings in relation to the approach to setting premiums. And your Lordships may have seen that there was a lot of cross-examination in relation to this issue. There were a lot of submissions in relation to this issue, and your Lordship has the detail of those submissions if necessary, and we can turn them up within the bundle. But the core point was that in relation to the analysis that we provided as to how this process had been conducted, the assessors concluded that they did not disagree with that analysis and did not disagree with our figures. And your Lordships have that note at paragraph 10, which contains the citation.
Which figures are we talking about here?
So, my Lord, this is the analysis that's set out in our closing submissions to the assessors in relation to the methodology, the approach that's been adopted, what goes into the mix, so to speak, and how the insurers went about calculating this premium.
What is it in terms of guidance, or in terms of the decisions of principle that we have to make in this case? Does this go to?
Well, Lord, what we say this goes to is that this court has the unique benefit of having this fact-finding analysis which has been conducted, and this court is in a unique position to say in relation to some of these aspects, whether these aspects are reasonable and recoverable or not.
No, I'm not sure that. So what is it you want us to say?
Well, Lord, there are a number of key aspects. The detail is all
Under this heading, approach to setting rules. What is it that you want this court to say?
Well, Lord, the key points that we have identified are as follows, and I can set them out very, very shortly. Lord, the first relates to the question of self-insurance of these premiums.
Sorry?
Self-insurance of the premiums.
Right.
So, in a nutshell, and I can expand this to the extent necessary, prior to April of 2013, under the different legislation that was in place, it was accepted that it was appropriate for the premium that was recoverable from the opponent to include the cost of that premium being insured against its own non-recoverability. So in other words, if the claimant did not recover that premium from the other side, then the insurer would not look to the claimant for the cost of that premium. That, of course, imposes a cost on the insurer, and that was a cost that could be passed on to the opponent in other cases where the claimants did succeed. And the net effect of that, and we can see it in Rogers, but the analysis was provided to the assessors and they didn't dispute it. The net effect of that varies depending on how the assessor, how the insurer risk rates their case. But in broad terms, if the risk rating is a 50-50 rating, the net effect of that is it doubles the premium cost. If the risk rating is more pessimistic than that, the net effect is greater than that. And so, for example, on a 40-60 risk rating, the insurer taking the view that there's a 40% chance of success, the net effect is that the premium is 1.5 times.
That was the position before April 2013.
So that was the position before April 2013. And we say that under the present legislation, the regulations that Mr. Bacon has taken you to, that element is not recoverable. Now that is a central issue. The assessors here have had the benefit of a fact-finding hearing.
It's a
Identified.
central issue to what?
Well, it's a central issue.
There's no respondent's notice.
My Lord, there isn't a respondent's notice.
So this involves picking through bits of the premium now.
Well, my Lord, it involves this court giving guidance as to recoverable elements of the premium. It's a position we've set out very clearly. It was set out in our arguments to the assessors. It was set out in our skeleton argument, and we are in the position here. One point, in fact, this court hasn't addressed yet is the nature of this hearing. It was proposed by the claimants that this was to be a rehearing in light of the additional factual evidence that had been adduced. That issue was never resolved at the directions hearing in front of Lord Justice Irwin, but that was the basis, we say, on which the fact-finding hearing was promulgated. And this court, as I say, this is not an exercise anybody wants to be going through again. This court has the benefit of
The
detail.
question is whether it's an exercise we want to be going through at all.
Well, my Lord, if it's not gone through, it will come back. The effect of self-insurance is huge in these cases. It more than doubles the premium that is charged.
Can we just deal with these points quite swiftly, and then we can take a view about, on principle, about whether we have as a rehearing or not. I have to say my eyebrows were raised when it was suggested we have a rehearing, as it were, on new evidence, but there we are.
Well, my Lord, there is a raft of new evidence before the court.
I appreciate that.
And the arguments that have been advanced on both sides, of course, are by reference to that.
It's one thing to have the evidence that was directed on the directions application as to the factual basis in this particular case as to whether there was another cheaper policy, or whether you can look as a matter of principle at other policies in what circumstances when they're block rated. You're looking at something different, but we're taking up more time debating about whether you should be able to advance these points and actually hearing what they are. So, what is the position post April 2013 in relation to a premium which, as it were, ensures whether the premium is recovered from the other side? Well, what is the position? You say under the present regulations that's not recoverable.
We say that is not.
And can you just tell me why that is?
Lord, yes, I can take you to the. If we go to the authorities.
If you were to give us the references in the assessor's report and any argument which you have formulated on this point, then our notes might be a bit more useful when we come to read them.
Well, of course.
So we've got in bundle 1 your closing submissions both of 8th April and 19th March. Is it the respondents' closing submissions of 8th April? We need to have something where we see your.
Lord, yes. Our position in relation to self-insurance was summarised in that addendum that I'd taken your lordships to, paragraph 24.
24.
24, and that contains references to the relevant sections of the assessor's report.
Yes, 24 the addendum. Yes, that's it.
I'm sorry, it's my fault, I'm sure.
No,
I do not know what you're talking about. Are you talking about an addendum to your submissions?
No, my lord. The Demouilpied skeleton before this court.
Before this court?
My lord, yes. And at the end of that, the internal pagination has internal pagination at the bottom of it, my lord. So it's the Demoulpied skeleton for the respondent.
And this is because the 2013 regulations say what is recoverable, what elements you can recover.
Indeed.
And so anything which is not within that is irrecoverable. That's your point.
Your lordship has the
I
argument.
understand.
Yes.
All right. Can we go to the next point?
Well, my lord, the second point in relation to it is a general concern that arose from the findings of the assessor, which is identified. Your lordships will just bear with me for a moment. Starting at paragraph 7 in that same addendum, again containing the relevant references.
One minute, let me just make a note here. This is paragraph 7.
Lord, yes, and it goes through to paragraph 11.
Approach to, so this is a third point. So we've had the first point was the fact of the tie between the solicitor and the insurer. The second point is the self-insurance premium point, and this is a third point, is it?
Well, my lord, yes, yes.
Right. So, and that's paragraph 7 to 11.
So, my lord, and the point that's identified at paragraph 7 to 11, if I can try and encapsulate it shortly,
Yes, thank you.
is that the evidence that came out is that the way the insurers underwrite this product is block rated, and they take a general view of the likely prospects of success. At the same time, they impose contractual requirements on the solicitors who sign up to the scheme.
I don't think it's entirely accurate to take a general view of the possible success. What they do is they fix the premium, having regard to their basket of cases,
Lord,
some
yes.
which they win, some which they don't win. That's how it works.
And,
They
Lord,
don't
yes.
look at they don't risk assess the individual case.
Correct.
Yes.
They form a view across the basket of cases by reference, amongst other things, to their past history in relation to similar cases, and then in relation to their anticipated,
Yes.
the anticipated outcome in similar in that basket of cases.
Yes.
And so that is set out, and it's set out within the detail that you have
So,
there.
and are you saying that's right or wrong? What do you want to say about that?
Well, Lord, what we say in relation to that is the evidence that came out illustrates that the way that is done is based generally on an assumption of a failure ratio, or of at least a failure ratio. So, in other words, how many of these cases will not succeed? Of, it would appear, generally in the region of 60%.
That's taking account of the whole basket.
That's taking account of the whole basket of clinical negligence cases which are being insured on this policy. And that's a failure rate of incurring a liability to pay the insured costs.
Yes.
Now, Lord, there are two things we say in relation to that. The core to this, though, is that what we say is that is requiring my clients to pay costs which are not reasonable, in that we are therefore we are paying for insurance which covers the presumption that the majority of these cases will fail. Now, one of the unusual aspects to this, of course, is that the insurers, and again it's dealt with in this same section, the insurers provide as a contractual requirement that there is a threshold for insurance under these policies, and again that was dealt with by the assessors and it's set out in the addendum. The general threshold is conventionally at least a 51% prospect of success in these cases, although the evidence as it came out late in the day in relation to ARAG, the particular insurer here, is that they have a sort of stepped threshold, which is that they won't insure cases where the solicitor doesn't say there's at least a 51% prospect, but they're not obliged to insure unless they're satisfied the prospects are at least 65%. So there's a section of cases below 51% which they don't insure under this scheme. There's a category of cases between 51 and 65 where the insurer isn't bound to offer the insurance, it retains a discretion, and then it's only if it's above 65% that the insurer can.
Are you criticising that, or I'm not quite
Well,
sure?
look, what we
What
are
is your
saying.
criticism?
Well, my lord, our criticism is that we say what the insurers are requiring the solicitors to do is how these matters should work. It is not reasonable for us as a matter of generality within these block-rated cases to be required to pay, which is the net effect of this, for cases which in the majority are not meritorious cases.
In the majority are not.
Not meritorious cases.
Well, just pausing there. I mean, what we're concerned with, this whole dispute is, in one aspect, is whether or not there are comparable policies in terms of comparable cover at a lower premium. Now, what I understand you to be doing now is to be challenging the way that the whole market operates.
Well, Lord, we are on that aspect. That is, we are saying that the evidence that the assessors have provided identifies that there is an unreasonable element to the premiums we are being required to pay.
Mr. Manager, if you're not required to pay in respect of the risk of cases which are not meritorious, you are rejecting any system of insurance.
Well, Lord, no.
By definition, the system depends on dealing with covering all cases, recovering the cost of that for those succeed to cover the cost of those that fail.
My
If
Lord,
you exclude all the non-meritorious cases, then there's no insurance system.
My Lord, no. The purpose of the insurance, we say, is to ensure that, provided that there is an adequate method of scrutiny, initial screening, to ensure that only cases which are prima facie meritorious are being insured, then of course that works. But what we say the evidence in front of the assessors showed is that the insurers are in fact assuming that across the board, across the whole basket, across year on year on year, that they will continually be providing insurance to cases which in the majority are going to fail.
I don't quite follow that, because we're only looking at these costs, because these are costs which your clients have to pay. Your clients are challenging paying these costs. So their challenge can only arise in meritorious cases, because they're cases in which your clients have either been found liable or are making a payment.
Well, my Lord, that would be right were it not, and this is why all of these matters
That's
tie
what
together.
happened in West and Demouilpied, which are the two cases with which we are concerned.
Well, Lord, absolutely, and that would be right were it not, which is why these matters tie together, for the fact that these policies the premiums of these policies all self-insure. So the cost that we are required to pay in a successful case includes the cost of the provision of the insurance to all of the claimants in the unsuccessful cases.
Which is the way that the market works.
Well, my Lord, insurance, of course, doesn't conventionally work on a self-insured basis. If we insure our car, we pay a premium, and if the fortuity happens, then we get the benefit of the insurance. What we don't normally have is a situation where, firstly, somebody else is paying for that insurance, and secondly, where that person is paying in effect through that policy, not just for the insurance in respect of that particular case.
Right,
But for the
you're not
insurance in
challenging.
respect
You're
of
not
other
challenging
cases.
here the way that the block-rated policies don't look at an individual case. You're not challenging
We are
that
not.
principle. You're simply saying that the underwriting process has an inbuilt that the underwriting process involves a higher premium than it should be, because taking a 60% failure rate is too high. Is that what you're saying?
In essence, yes. We are saying that.
What do you say the figure should be?
Well, my Lord, we say that if we are required, bearing in mind this is across the market, so this is a different point from the point that the assessors make, which is if you look at an individual case, it might reasonably be decided at the start of that case that it's got at least 50% prospects. And to go to my Lord Justice Irwin's point, if that case subsequently fails, well, in fact, it wasn't a good case after all. It's a case that's failed. That's different from the point that across the market, across the basket.
You're making it, but what do you say would be a reasonable rate of failure assumption that would be reasonable?
Well, we say you can take that quite reasonably from what the insurers themselves expect, which is that they should not be insuring cases which have a worse than 51% prospect.
So
of
you're saying it should be a 51% assumption.
Lord, yes, and we say that if the process is working properly, of course, in an individual case, you may have a case where you say it is better than 50%,
Just
but it
pausing
turns out
there.
to fail.
You're making that proposition as counsel. The assessors haven't made that statement.
They have not.
So we have no expert evidence, no assessor statement. It's your proposition.
Well, Lord, the assessors have identified the facts as to that the way we have identified is the way that it is rated. They have reached no conclusion.
So are there any other...
Say,
That's not right, Mr. Bailey, is it?
well, the conclusion that they have reached, I think, is that the way they put it is the insurers were doing the best they could in the circumstances that they were in, and they do not consider.
They don't consider the 51% point as a reasonable figure.
They don't consider essentially what's the legal argument, which is it is not reasonable for my clients across a basket to be expected to pay costs where the overall prospects of those cases do not satisfy at least a 50% threshold. And we say that there's support from this proposition. The point that was one of the points that was identified by the assessors in paragraph.
Okay, 1 minute.
You should read I'm very concerned. I didn't. Can I rudely interrupt? But it's somewhat frustrating. 201 to 204 completely nails this point, Miss Mullins.
No, I think, could you, we want to try, I understand your frustration, Mr Bacon, I've been there myself, but could you please reserve your comments, I think, on this point to reply? Right, now, rather than you taking us through everything in relation to this, you say there's some support, could you just give us the references, please?
So, my lord, in terms of the references to the material facts, your lordships will just give me a moment.
Is it not set out in your
it is. It's set out in the addendum, and
well,
that
can we not just read the addendum?
my lord,
Because you've got the point of principle.
you have, and the references are set out in the addendum.
So we should see the references in the addendum. Right. Anything else?
And your lordship will see when your lordship goes through that the detail is set out as to how this calculation
This
is.
is paragraph 7 to 11.
It is, my lord. Your lordship will see in paragraph 7 to 11 the various references to how this calculation is carried out, to the approach to prospects of success, and also to the building blocks of the way the premium is calculated, which we all say go to a concern.
You say the assessors missed the core point.
No, my lord, we don't say
paragraph
the assessors.
12.
Well, what we say is, insofar as the assessors concluded, and I think it's the point that Mr Bacon wants me to highlight, which is the assessors concluded that they said it would take a wide-ranging and detailed review and possibly expert evidence to come to any firm conclusion on precise reasons for the failure rates experienced by these insurers, and that without it there was no proper basis for drawing the conclusion. Now, we say that's where it comes to our submission, that is missing the point. The point is not the reasons for the failure rates. The point is that the evidence clearly shows that not merely the expectation, but the practical reality in the core to the calculation of this premium is that we are being expected
I think we've got that.
constantly.
So are those the 3 points you want to
So, my lord, your lordship will just give me a moment.
I think we'd like to start tomorrow with a clean slate getting into the points.
So, my lord, the further point that was expressly highlighted and that was dealt with in detail, and it's in, if I can go back to the addendum, my lord, it's paragraph. It's in the skeleton argument in the West case. Your lordship, give me a moment. It's internal pagination, page 19, paragraph 90 of that, and just in passing, your lordships will see on page 18.
Sorry, which skeleton are we looking at?
Sorry, Lord, it's the West skeleton argument.
Yes.
So internal pagination, if you start on page 18, your lordship will see set out there the legal argument in relation to the self-insurance point. So the addendum sets out the factual references.
We've dealt with that.
My lord, yes, and then over the page on page 90, your lordship will see the further issue that arose, which is what's under the heading other specific elements which make the premium unreasonable or irrecoverable. And within that, we identified 2 aspects. The key aspect, the most significant, we would say, is that at paragraph 90. And the point, the point there is that, as your lordships will know, these regulations allow the claimant to recover against the cost of insuring against incurring a liability to pay for expert reports on liability and causation.
Well, I think we've read that, and I think that's clear enough, your point there. And then you've got commission profits and overheads.
Lord, yes. And again, the point is set out there. It's set out fairly shortly. Your lordships may say that that's a matter to be looked at in individual cases rather than one that benefits for any wider guidance, but our point is that it was considered here by the assessors. We have the figures, and we say that there is a real question raised, therefore, and as to the level that this particular insurer is charging. And again, this is a situation where that challenge essentially rests on evidence that we have through the assessors now, but from other policies and from other cases as to what other insurers charge in similar circumstances.
How long do you think you're going to be tomorrow?
Lord, I have the core issues of reasonableness and proportionality to address. I anticipate I will, subject to any direction from your lordships, take the morning or most thereof. Whether I tread into the afternoon may depend on how many questions your lordships have.
Well, I'd have thought with the examination we've had so far of the case and the debate so far we've had with Mr Bacon, we've probably ought to finish by the latest short adjournment. Thank you very much.
Stand, please.